All right, good morning, everyone. This is Fremont County cases CR 22-2755, State versus Chad Daybell, and Fremont County case CR 22-2838, State versus Lori Daybell. This is the time scheduled for a hearing on the defendant's motions to disqualify the prosecuting attorney. Those were both filed on December 15th. State filed its objection a day later on December 16th. Representing the state of Idaho in this case, let's see, Mr. Evans, are you going to be arguing the motion today or the opposition to the motion?
I am, Your Honor.
Okay, Troy Evans for state of Idaho on behalf of Special Prosecuting Attorney Madison County Prosecuting Attorney's Office. Representing Mr. Daybell is Attorney John Pryor. Mr. Pryor, can you hear me okay?
Yes, Your Honor, I can. Thank you.
All right, thank you. And then representing Ms. Fallows, Attorney Mark Means. Mr. Means, can you hear me okay?
I can, Your Honor. Thank you.
All right, thank you. Counsel, pursuant to the Idaho Supreme Court's most recent order regarding our court operations during the COVID-19 pandemic, we're conducting this hearing by Zoom. The hearing is being recorded on the Zoom software. It's also being recorded on our FTR system out of Fremont County, and it's also being reported by the court reporter. In addition, in order to allow access by the public to this hearing and help mitigate the spread of COVID-19, we are live streaming this hearing on the court's YouTube channel. Because we have a court reporter for this hearing, counsel, I would also make sure to ask you to refrain from speaking over one another so that we can make sure to take an accurate record of these proceedings. This hearing today will take place, as I mentioned, over Zoom. I would note, I'll address Mr. Pryor and Mr. Means. Your clients are not here present. Obviously, they do have the right to attend this hearing. I've been advised that each of them have chosen not to attend this hearing, although arrangements were provided for them to do so. Let me first ask you on that, Mr. Pryor. Have you spoken to your client directly about his right to appear at this hearing?
Yes, Your Honor.
And was it his intention to not appear today?
That is correct, Your Honor.
All right, thank you, Mr. Pryor. Mr. Means, I'll ask you the same thing. Did you speak to your client about her right to attend the hearing today?
I did, Your Honor.
And was it her decision to not attend the hearing today?
Correct, Your Honor. Yes.
All right, thanks, counsel. On these motions, then I'll just ask both Mr. Pryor and Mr. Means have filed individual motions. They cover a lot of the same issues or maybe all the same issues. Are the parties both ready to proceed at this time?
I am, Your Honor.
Yes, Your Honor.
All right, and Mr. Evans, is the state ready to proceed this morning?
Yes.
Thank you. As I mentioned, each defendant has filed a motion to disqualify the prosecuting attorney, and the state filed an objection. I've reviewed those filings as well as the proposed witness and exhibit list that I've received from defense counsel. Pursuant to the court's previous December 17th and December 21st orders, some of those filings were filed under seal. I also received the stipulation for admission of certain exhibits that was filed yesterday. In terms of the procedure of this hearing, my intent would be to first allow Mr. Pryor to call his witnesses and present any evidence, of course, subject to cross-examination. I would then allow Mr. Means to put on his case in terms of arguing the motion. After that, my intent would be to have the state argue in response after both the defendants have presented their motions. And then finally, if there's any request for rebuttal argument after the state goes, then I would consider that. So, counsel, does that make sense in terms of the order of conducting this hearing today?
It does, Your Honor.
Yes.
Okay, thank you. In terms of submitting evidence where we are doing this remotely, of course, we have to go through the process to get it admitted in the hearing and offered as if it were an in-person court hearing. If we run into any kind of technical difficulties, I guess everyone be patient. We've got support here to help us work through any of those issues to make sure any exhibits or other evidence are properly submitted for the hearing. But don't think that we're under any kind of intense time pressure or anything. If we need to take a moment to sort through issues regarding those technical aspects, I understand there are issues that come up frequently as we do things remote. So With that in mind then, let's go ahead and get started on the hearing. As I mentioned, Mr. Pryor, I'll allow you to proceed first with your motion to disqualify. If you'd like to call your first witness or make any opening statement, you can do that.
Judge, prior to calling any witnesses, my understanding is that all of the parties have agreed and have stipulated by signed stipulation presented to the court that the transcript of the recording and the recording itself may be entered as an exhibit in this case. So I would respectfully ask the court at this time to have the transcript as Exhibit 1, the recording as Exhibit 2, marked and admitted as an exhibit in this particular, as exhibits, excuse me, in this particular case. And I understand that all of the parties have stipulated, so I do not anticipate any objection.
All right, so I did receive the stipulation, and we will mark then the transcript. And that is, to be clear, the transcript prepared by Nagley reporting that was submitted by the court of a recording made on Thursday, October 1st, 2020. And by stipulation of the parties, then that will be marked as Exhibit 1 and entered. And then the recording will be, obviously there's no physical exhibit, but there is a file that would be the audio recording that will be Exhibit number 2. And it is also admitted by the previously submitted stipulation of the parties. All right, Mr. Pryor.
Yes, Judge. Judge, at this time, we would seek the publication of Exhibit number 2 and have it broadcast.
Very well. So Mr. Pryor, typically if you're the one offering or publishing it, then you would play that recording from your destination, and then it would be broadcast over Zoom and on the live stream.
Right. And Judge, my understanding, and Mr. Means and I spoke earlier today, that he has the recording and he's prepared to play that. I would ask Mr. Means to do that.
Okay. Mr.
Your Honor, and I can do that. And a question I have for the court is, I believe the first witness that Mr. Pryor intends to call is Attorney Garrett Smith. He is the one who created the recording and provided it to counsel. Given the Zoom nature of this, he's in the waiting room to join the meeting. I think it would make a lot of sense for any kind of questions of what's been alleged by the prosecution as far as editing or deleting or altering of this recording, that Mr. Smith would be allowed to listen to the recording being played.
All right, in terms of that request, if we were to do that, Mr. Means, then I would think he would need to be actually brought into the hearing as if he were called as a witness and placed under oath before he were admitted for any other purpose. So
Agreed.
Wish to do that at this time. And Mr. Pryor, you're the one really proceeding here, but do you wish to have Mr. Smith brought in and placed under oath for future?
Yes, Judge.
Okay. All right, Madam Clerk, if you would admit Garrett Smith, the witness, and then once you've established that he's here, let's go ahead and place him under oath. Mr. Smith, this is Judge Boyce. Can you hear me okay?
Yes, Judge.
All right, good morning. You've been called as a witness in this hearing. I'm going to ask you raise your right hand, and I'll ask Madam Clerk to administer the oath, please.
Do you solemnly swear or affirm that the testimony you're about to give in the cause now pending will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right, Mr. Pryor, you can proceed.
Mr. Smith, will you state your name, spell your last name for the record for me, please, sir?
Garrett Smith, S-M-I-T-H.
Mr. Smith, how are you employed, sir?
I'm an attorney,
Okay, and out of what jurisdiction, sir?
Arizona.
Okay. Do you know the name Summer Shiflet?
Yes.
Okay. Do you know the name Zulema Pastenes?
Yes.
How do you know them?
They're my clients.
Okay. Did you have an occasion to have a meeting with Mr. Rob Wood sometime in October?
Yes.
As a part of that meeting, did you advise Mr. Wood prior to the meeting that you would be recording that conversation and meeting?
I don't know if I said it like, that I was going to be, having a recorder on the table, but that, that there would be concern for what my clients were testifying about in future purposes for, if they were to testify in the future, to be consistent with what they were testifying about. He told me they were going to be recording it, obviously, because it was a police investigation. So, specifically, I don't remember if I told him that I was going to record that or not. But I mean, there was discussion about it, but I don't know that I came out and said, well, I'll be making my own recordings of that interview. I don't know that I ever,
Okay.
I don't know that I ever said that to him specifically.
Okay. And Arizona is a one-state recording state, is that correct?
Yes.
You have every right to record that conversation without any concern about violating the law, is that correct?
That's absolutely correct.
Okay. And you did in fact record that conversation, is that correct?
I did.
You recorded a conversation of Mr. Wood talking with Summer Shiflet, is that correct?
Correct.
And then subsequently, you also recorded the follow-up with the police interviewing Summer Shiflet, is that correct?
To be candid, I believe it was the same recording. I believe that when I went into the Chandler Police Department on that date, I turned my recorder on. And I believe it was one continuous recording of the entire exposure with the Chandler Police Department, including the initial conversation with Mr. Wood.
And that's what you anticipated my question. So in other words, when you turned your recorder on, it was a complete recording of the entire conversation between Mr. Wood as well as the Chandler Police Department in interviewing Summer Shiflet. Is that correct?
The only word I'm not comfortable with in that sentence is complete. I don't remember when I turned it on. My recollection is that I turned it on when I first walked in. I may have turned it on after having been in the lobby for a few minutes. Logistically, this is how it worked out. We walked into the lobby of the Chandler Police Department. Mr. Wood and several others came out to meet us. And then we went into a room with Mr. Wood, his deputy, and my client. And it was prior to that I turned on the recording device. I don't remember when I turned it on specifically. I'd have to listen to the very beginning of it again just to remind myself of that. But it was prior to going into the room with Mr. Wood and his deputy and my client.
Okay. And we're going to have an opportunity to listen to that tape in a moment or two. But so your recollection is that the entire recording, other than you, given your representations, were recorded as an entire document. In other words, you had your recording, and at no time did you turn it off. Is that correct?
That's my recollection, yes.
Okay. At no time did you modify or edit it. Is that correct?
That's correct.
And at no time did you make any changes to that recording. Is that correct?
None.
Okay. But the recording was one in a complete document that included not only Mr. Wood's discussion with Summer Shiflet prior to the interview by the police, but also the interview by the police of Summer Shiflet. Is that correct?
That's correct.
Now, it's at some point then you presented that audio tape to Mr. Woods. Is that correct?
I did not present it to Mr. Woods, no.
You provided Mr. Woods a copy of a tape recording.
I did not.
You provided the discussion between Mr. Woods and Summer Shiflet to Mr. Means. I'm sorry, I said to Mr. Woods.
Yes, sorry,
Mr.
right,
Woods,
yes.
I apologize.
Yeah, I don't believe I ever gave a copy of it to Mr. Woods, but
Right.
I did send a copy. When Mr. Means requested it, I got permission from my client and sent it to him.
Okay, and I apologize, I misspoke.
That's okay. A lot of parties.
Yeah. So at some point you presented the recording to Mr. Means, is that correct?
Correct.
Prior to presenting it to Mr. Means, did you take any other actions in regards to this recording?
I did. Before I did anything, I contacted the State Bar of Arizona. I sought counsel from them with regard to a couple of things. Number one was what I needed to do to disclose it. And if I could, given the fact that it was recording for a client and that kind of a thing. And we had a long discussion as well about the legality and the ethics of recording another attorney. And and about, somewhat the substance of the call,
Okay.
but not as much about that. I wasn't as concerned about my bar's opinion on that.
Okay. So may I inquire of you, what were your concerns about why you felt you needed to disclose it to Mr. Means?
Why I could or couldn't?
Why you did? Why did you take that action?
Because Arizona has had a long history of ethics and opinions with regard to recording of opposing counsel or other counsel. And don't cite me on this, but I believe it was a 1977 ethics opinion that came out and said, Arizona, we're not going to record each other. And then there were 3 other opinions that were issued with regard to that indicated multiple exceptions to when recordings could be made.
Okay.
And so I just wanted to be clear about it. I thought I was well within my ethics to record a conversation. One of the exceptions is to protect a client's exposure for perjury. And, so I wanted to know exactly what they said when they made statements to the police.
So
and that was my reason for inquiring.
So I guess you led into my question.
Yeah.
You had concerns while you were present in that meeting that your client may be susceptible to perjury charges. Is that correct?
Absolutely.
And as part of that discussion, you were concerned that Mr. Woods was coercing your client, Ms. Shiflet. Is that correct?
Well, I didn't have the concern going into that, but obviously it's not why I turned on the recorder. But during the conversation, I was concerned about the conversation that they had.
And at this point, upon participating in that meeting, you strongly felt that Ms. Shiflet had been influenced by Mr. Wood. Is that correct?
I was bothered by it to the point where I called Mr. Means and said, you got to be aware of a few things.
Okay. And what specifically bothered you?
It bothered me that there was discussion about potential punishment for my client's sister. Mr. Wood was well aware of the emotional relationship between my client and the defendant, Lori Daybell Vallow, or whatever we're calling her.
Okay.
There was a recording that Mr. Wood heard between my client and her where my client was just vehemently upset and angry, and you could tell the emotional turmoil that she was going through. And I thought it concerned me that he was discussing potential death penalty results for my client. It concerned me that he was discussing the theory of the case with my client prior to her being interviewed. It concerned me that he was saying things about Mr. Means and his competency to handle this case. He said it not only to my client, but if my recollection's correct, he was kind of inferring that I wasn't aware of Mr. Means' level of experience and that, he was in over his head on this case. It wasn't my experience in interacting with Mr. Means. And I was concerned about that. I thought it was at a minimum unprofessional. On the other level, placing yourself in an improper role with a witness to have those kinds of discussions.
And the improper role you talked about is Mr. Wood, in essence, was turning himself in as a witness in this case, suggesting the theory of the case to a material witness. Is that correct?
Well, and not only that, but offering evidence about some of the witnesses, in terms of his interactions with Mr. Daybell, those kinds of things. I just saw no purpose for that. Other than to have a discussion with a witness. I also thought it was, and I was in the room. I was part of the discussion. I don't think I had much to say during it all, but there were just it was described as kind of an introductory conversation. We had a similar one with my client, Zulema Pastenes, but that one had more to do with her use immunity agreement and just kind of finalizing those details and getting that signed and things like that. But this was, just want to take a chance to say hi and things like that, which I get. It's important to know the parties, but the conversation didn't go that way. It wasn't like, hi, I'm the prosecutor, this is my deputy, and we're going to be the ones in the room that you're not seeing, listening to the interviews. That kind of stuff I would have expected. But, I've been practicing, and you've not asked me this, I've been practicing for 27 years. It was curious. I hadn't seen anything like it. I was curious about what the purpose of it all was. It was much longer than it needed to be a simple introductory conversation. And there was, like I said, several things in the conversation that were said that made, buzzers go off in my head.
Okay. I want to lay a little bit of additional foundation in regards to the recording. My understanding is that Mr. Wood had approached you and said, I want to come down to Chandler, Arizona to do a meet and greet with Summer Shiflet and Zulema Pastenes. Is that your recollection?
I don't think that's exactly how the conversation went. To be candid, I think it was always in terms of, we are going to come down there. We're going to be interviewing other witnesses. We'd like to speak to your clients. They were interested in speaking to Summer and Zulema and Melanie and Ian. That was the ones they had spoken to me about. It was not a meet and greet. It was an interview. I took it to be a formal, the police are going to be coming, the FBI, the, other law enforcement officials are going to be sitting in there with regard to the multiple investigations that are ongoing, to which my clients are directly or tangentially involved. And so it wasn't, Rob Wood, the prosecutor, coming down to meet these people. It was the legal team that was prosecuting this case coming down to conduct interviews in a formal investigation.
So when the witnesses are going to be interviewed by the police, you anticipated that as part of this process. Is that correct?
Correct.
And you anticipated that Mr. Wood advised you that he was going to come down and introduce himself to your two clients. Is that correct?
I don't know that he said it in those terms, to be candid with you, Mr. Pryor. I think I knew that he was going to be here. I kind of implied that he was going to be here based on the conversations that he was saying we're going to be coming down there.
Yeah.
I've participated in many interviews with investigations where the prosecutor participates and where he doesn't participate. And I don't know if he was intending to be an active part of that investigation or do anything. I've had it where the prosecutor sits in the room the entire time and is part of the process or is proposing questions to the investigator. I didn't know what the logistics of it were going to look like, but I did have an understanding that he was going to be there.
Did you have an understanding that after Mr. Wood introduced himself, that he was going to question, or excuse me, and I misspoke. Did you have an anticipation that Mr. Wood was going to introduce himself to Summer Shiflet and then proceed with 18 minutes of discussing the case with Summer Shiflet without asking only one question?
I didn't have any idea what that meeting was going to be like, other than, as I said, my 27 years of experience. I expected there to be some handshaking at the beginning, and then, we'd go into the formal business that we were there to do.
Okay.
He did not anticipate to me in any way, shape, or form, or maybe not the word anticipate, but he did not forecast in any way to me that type of a conversation was going to take place. No.
Were you the party initiating the contact with your client Summer Shiflet and Zulema Pastenes, or was it Mr. Wood initiating and trying to set up the interview process?
No, this was initiated by the prosecutorial, or the prosecutor and his investigators. And to be candid, John, I don't remember, Mr. Pryor, sorry. I don't remember who contacted me first, if it was the investigators or Mr. Wood, but I had been contacted by both the investigators and Mr. Wood with regard to the interviews. We had been trying to set it up for a while. I think this was our second or third attempt to get them scheduled. I think second attempt. And no, I did not initiate that. Both of my clients were pretty much done talking about this case, other than when they needed to. So I wasn't reaching out to anybody to say, hey, they want to talk to you. If that's what you're asking. This was in response to a call and a question that they wanted to speak to my clients.
Okay. So I want to go through some of the concerns you have. Now, you're familiar with the ABA rules of professional conduct, are you not?
As a practicing lawyer, I am.
And that's part of every lawyer's training. And on my recollection, it's been some time, and we share a similar length, or at least close to a similar length of time in practicing. But ethics is taught, I believe, in the first year of law school, is it not?
You know, I don't remember when I took my ethics class. It was within the first 3 years for sure.
But ethics is an important part of the process of being trained to be an attorney and being
Absolutely.
educated as being an attorney. Is that correct?
Correct.
And there are specific rules that attorneys are bound by in terms of ethics. Is that correct?
Correct.
And there are specific rules that a prosecutor is bound by in terms of ethics as well. Is that correct?
That's correct.
And as a former prosecutor, my prosecutorial experience is very limited, but and I didn't get into your experience, but as a former prosecutor, you're well aware of your ethical obligations, right?
I was a prosecutor for 3 years for Maricopa County, which is the largest prosecuting agency in the state of Arizona. And yes, I'm aware of those duties.
Okay, and part of that ethics responsibility is the administration of justice. Is that right?
One of them.
And that's one of the responsibilities to make sure that justice is performed evenly and fairly, and that both parties are afforded a fair opportunity to present their cases. Is that right?
Yeah, I mean, the way I always looked at it as a prosecutor was it's adversarial, but it's not win at any cost. You have to do justice first. And, you know, there's certain standards and not certain, there are standards that are higher than for a normal adversarial process for a prosecutor.
Well, what that means is the prosecutor has to conduct himself in a manner that doesn't interfere with the administration of a fair and impartial trial in front of a jury. Is that a fair assessment?
I agree.
And you would probably understand that every jurisdiction, including Idaho, has rules of professional conduct that are all similar based on the ABA rules. You would agree with that, right?
Yeah, I'm not as familiar with Idaho, obviously. I've never practiced there or done anything, but I'd be shocked if they didn't have rules that mirrored the ABA standards and Arizona standards for that matter.
Okay. So I want to go into a few specifics in regards to the recording that you provided to Mr. Means. You talked initially about Mr. Wood discussing with Summer Shiflet the prospect of going forward on a conspiracy to commit murder charge. Can you elaborate on that a little bit for me?
Well, he had a conversation with her, and I don't recall the exact specifics about it, other than it was brought up that, I mean, it was an awkward moment. You know, my client was expressing her, at some point in the conversation, was expressing her ambivalence or not ambivalence, or kind of being juxtapositioned in this case. She was here testifying on behalf for the state in an interview, going to be offering testimony that was potentially going to be used to harm her sister. And that bothered her on some level because she was, you know, she loves her sister, and she expressed that to Mr. Woods. And then to have him talk about, you know, bring up in that same context or in that same conversation, the fact that he's going to be going forward potentially with charges that could result in the death penalty for her sister was that concerned me. I didn't think it was necessary. I don't know what purpose it served other than to, you know, put a thumb on my client and to, you know, attempt to, you know, elicit testimony from her that would be favorable to what they were trying to do. And there was a difference here because it had been made clear to me, and it was made clear to my client in that meeting, that what they were most interested in was information about Mr. Daybell, and that they had a solid case against my client. And I had communicated that to them. You know, there were preamble conversations to this conversation that we had the day of the interview. Mr. Wood and I and the investigators had spoken about this case. They told me their theory of the case. They told me what they were looking for and what they were angling towards. And they definitely, I was aware of what they were doing and where they were going with this. And so to have him then say those same things to my client that day, I felt unnecessary. And I mean, I'm a nice filter. You tell me that you're considering the death penalty against my client, and I can express that to her in a setting that's appropriate.
Well, it's not the death penalty against your client, it's against his her
Right.
sister, her own sister.
And I'm sorry, I got to pause for 1 second. There is someone knocking on my door and no one is here to answer it. So if I can pause for 1 second and put you guys on mute.
Well, Judge, if we could do this, I think at this point, it may be an opportune time for us to listen to the 18-minute conversation between Mr. Wood and Summer Shiflet. If I could ask the court to allow that tape recording to be published once Mr. Smith comes back.
Well, my concern there is we're in the middle of this line of questioning and I have not provided an opportunity for cross-examination yet. So I'd like to take that up first before we get the request. And it looks like Mr. Smith's already back.
Okay.
Sorry, I just need to answer my door. I apologize.
All right.
Working from home has its own exposure.
And Judge, at this time, it's my preference that the court allow us to publish the tape, allow Mr. Smith to listen to and review the tape before I proceed with any additional questioning. In no way do I want to impede the prosecutor's ability to question Mr. Smith, but I think this would be a good opportunity for that tape to be played to allow all the parties to listen to exactly what I'm referring to.
Okay, well, the conversation, the recording of that's been admitted in the hearing, so you can go ahead and publish that at this time, Mr. Pryor, if you so choose.
And Mr. Means, you had spoken to me earlier this morning and indicating that you had that available. I would defer to you if you could record, if you could publish that for us, please, sir.
Will do.
They're the ones kind of running down the kid's case because they were last seen in Rexburg. Or were last living in Rexburg.
Right.
Tylee was last seen in Yellowstone, but and so we were the ones that like knew everything about the case, and so they assigned us on that. I'm just going to tell you right now, we are going to be filing conspiracy to commit murder charges against both Chad and Lori.
Good.
And we're not shy about that. I've told their attorneys.
Okay.
His attorney keeps pretending like I've never said that. Whatever. What? But we have to.
Yeah.
We have to. But I kind of want to give you like a little bit of background of where we are and kind of like our kind of theory of how this ended up where it was. We know that this is not the same Lori everyone else knew. What's so strange to me is everyone we talked to who knew Lori before this, right? Well, she was primary president. She made quilts for these kids. She made everything fun.
Mhm.
Everyone loved her. She loved everyone.
Great mom.
Great mom. That's what everyone says. And you know, so the one thing I'm going to kind of ask you to consider is maybe something happened. I don't know what. I don't know if it's psychological. I don't know. I don't know if we'll ever know. But something happened, and I think Colby, the way he said it to me, I think is kind of it's like the person who's in that jail cell is not my mom, it's someone else.
Yeah.
The flip side of that is that I shouldn't say the flip side, but I want to be clear. I'm not going to pull any punches on any defendant in this case, right? Like I've got my job to do. And,
Absolutely.
but we also want the truth and the whole truth and the context of it. And Chad Daybell is, did you ever meet Chad?
So I met him once at a preparing people. I went to one preparing people thing, and my mom and husband and I went to support Lori, and she wanted to support Mel. So we went and met Chad after he talked for like 90 seconds, maybe, if that. And then he called me when Lori got transferred to the Idaho jail. He texted me and said Lori wanted to talk to me. And I was like, yeah. And then the second I hung up with her, he called me to ask me about bail for Lori. So I've talked to him maybe 3 times briefly on the phone, never a long extended conversation. But the first thing he said to me when he called me was that he said, Lori hasn't told me very much about the kids. So there's not really much I can tell you about it.
Right, of course you said that. Well, welcome to Chad Daybell. So what I want to kind of tell you,
I have my own opinions formed of him after all.
I bet you do.
Yeah.
He's highly manipulative.
Yeah, I see that.
I'm not going to say he's highly intelligent, but you don't have to be highly intelligent to be highly manipulative.
Absolutely.
He is extremely manipulative, and and I want to, your sister manipulated him in some ways too, but the context for everything that happened came from Chad.
Absolutely.
And unfortunately, we have enough evidence to prosecute him, and we are. The case against your sister is stronger. But I kind of want to give you that background. That's kind of the context we see this as. Like, this guy came in here and, again, I'm not making excuses for anyone, but kind of blew up this situation.
Mm-hmm.
And he did not care who died,
Mm-hmm.
who got hurt. He did not care at all. And the other thing I'm going to tell you is your sister truly believes that everything she's done has been done in righteousness.
I know.
And I know I'm kind of using LDS speak.
Yeah,
It's 100%. That's my interpretation also.
Yeah.
I think she 100%
She believes it.
Mm-hmm.
Every once in a while, you'll see kind of a little crack in like a jail phone call. Or she'll.
Well, you've heard our conversation, so you know that I get that she's not fully aware of what she's really done.
Right.
Yeah.
Yeah.
I don't think she is.
Yeah, I mean, I'm going to say it this way. I think she knows what she's done.
She knew enough to lie to us about it.
Yeah, but the context under which it was done was this religious, just these ideas that are out there. I can say this because I am LDS, like no basis in the LDS faith. You said it in your phone call to her. So anyway, that's kind of where we're at. And but again, we're just really grateful for you coming in. And it's going to be hard to talk about these things.
Oh, yeah.
We know that. And they're going to be nice. Because obviously, you're not even a person of interest.
Yeah,
in this.
we've had
You're
that
not-
conversation. So.
Yeah.
Yeah. And, but part of what we need to do is understand when you have a case like this, it's not like just like a meth case, like, oh, you had meth, no one cares who you are. And
Yeah, there's no drugs, no alcohol.
Yeah.
It's just
But
so
this
bizarre.
case is
Yeah.
we need to understand the context of who these people are.
Yeah.
And so that's a lot of what they're going to be asking you about.
Okay.
And
I'll do my best.
like I said, it won't be easy. I know it's going to be a hard interview for you, but
I was wondering if you would be willing to tell me, if you're able to tell me, if there's any progress in what you know about Tylee and her death. Is there any progress in her autopsy where you understand better?
all I can tell, well,
I mean, do you have a cause yet, or is it close to one?
she is at the FBI's state-of-the-art crime lab. Unfortunately, there's a lot of deceased bodies there that they're going through.
I'm sure.
And so we're not, we don't know really any more yet. And we may never know due to the the destruction of that body. And we hope we'll find out. We may not, but obviously we know it's her. There was soft tissue that was still preserved enough to do DNA tests.
Yeah, I'm thankful you guys found them.
Yeah.
We wouldn't have ever known.
Yeah.
And I would have never dreamed that she would have ever heard them. So.
You know what? And everyone says that.
Yeah.
That's what everybody says. I never would have. So it's a tragic thing.
It really is. Yeah.
And but I just want you to know how grateful we are. I know you don't have to talk to us, and so we're just grateful that you're willing to and helping us that way. And I'm sure kind of difficult knowing like they're asking you for information that's going to help them in a case against your sister, but I guess the thing I want you to know is our whole goal is just justice for these kids, you know, and our hope as it comes to it. Your sister's actually made some overtures. She might be willing to talk to us.
I hope she does. I pray for
We-
that all the time.
We hope she does.
Yeah.
She actually was talking with Chad about talking to us before we found the bodies, just a few days before, and he talked her out of it, which is too bad. It would have been better for her to tell
Yeah,
us.
sure. Would
I
have
agree.
I mean, we were actually just finishing up our warrant on the day that she said that. We were just getting ready to go out there, but it would have been, that would have been even better, and he talked her out of it.
Yeah.
And then the night before, she says to him again, like, hey, what do you think about, and he uses this kind of, I call it spiritual abuse, spiritual manipulation.
Yeah.
We've all seen that guy in the LDS religion whose wife has to obey him because he has the priesthood type thing. And that's not what he says, but it's the same type of thing. Well, I'm the visionary guy. So, anyway, again, I just wanted to meet with you real quick, introduce myself and Mackenzie.
I've obviously seen you.
Yes, yeah.
But I don't take any joy in doing anything that's going to harm her. I don't take joy in her spending her life in prison. There's nothing.
Sure.
It hurts to think about her being in there.
There's nothing good about a case like this.
There's
right?
nothing good about it.
Even if you win a case, like Garrett's been in court, like there's cases, even as a prosecutor, like you take to trial and you win, and you're like, even at the end, you're like, well, nothing good it's all bad.
Yeah.
It's all bad.
The one thing, I said this to someone the other day who knows your sister, is our goal is sometimes you get a murder and all you have is that murder and you just have to run out and charge it and then kind of put it together. We were able to put them in jail with a high bail on these lower charges and put together a case. And our goal is to have such a strong case that when she has competent counsel, I don't know if you know this, her attorney's never handled a felony before. He has never done any meaningful criminal work at all, and he doesn't know what he's doing. He's a nice guy,
Yeah.
other when he's lying about me, but he doesn't know what he's doing. And once we file further charges, she will be appointed counsel who will know what they're doing. And our goal is to put together such a case that they're smart enough to say, it's going to be better to talk. And I think we are. And make it easier for everyone, make it easier, especially, for Colby. Like, if there's someone who's lost everything, it's him. So anyway, I mainly just wanted to thank you for coming and being with us. And
It's weird to be on the prosecution and defense's side at the same time because I love everybody.
Well, it's a system. I did defense work for I did it for 5 years, and I actually really enjoyed it. I thought it was a lot of fun.
I like defending.
And I gave me that perspective, right? Like, just because someone's committed a crime doesn't mean they're a horrible person.
So I'm so torn with it's such a conflicting feeling to know that this person's been good her whole life and then has made this error in judgment and got sucked into this vortex of this man. And I feel for her. I just have so much compassion towards her because I know that's not what she would have ever done on her own.
Right.
And so she has to pay the price for this forever. And I hate that for her. So I'm very conflicted. But I was going to ask you on the concealment, or not the concealment, but on the conspiracy to commit murder, what's the weight of that in terms of jail time? Is that a death penalty thing? Or
it is a death penalty case in Idaho.
Are you planning to ask for that for them, or do you not?
We sure hope we don't. Okay. A lot of that will depend on her.
Okay.
And it's that's not a decision, or that's a decision we don't make actually until usually after the case is filed.
Okay.
In Idaho, we have a couple months, because a lot of times you file it, it's out there on the table, and then oftentimes that's a big motivator for people to get together and talk and try and resolve it. And that's what we hope happens. I have no desire to do that. Plus, once you do that, it's endless appeals.
Yeah.
I don't think the other family wants it at all, because it's the
prolonged.
case just never resolves, really, in a way. Just kind of, they appeal this and they appeal that, and it can go on forever. So we're sure hoping not to go down there. Now, I'm not saying I won't. If we go to trial, I might, but we haven't made up our minds on that.
Okay.
But we don't want to. I can tell you that from the bottom of my heart.
Knowing her, if she comes out of this state and realizes the weight of it, she may prefer that, honestly. I think about that all the time with her, just because of what she's been through.
I'm just kidding. Well, I know that you know a lot more about Lori than I do. But we have learned a lot about Lori, and there's, I mean, there's been some things happen in her life, I think, that have played into this.
Oh, definitely.
And but yeah, like I said, I talk of that in a one way a little bit sure, but I want you to know that I have no desire to.
Yeah, I think you see it for what it is.
Yeah, it's not.
I don't know how you couldn't with interviewing everybody.
Well, I mean, I'll tell you, when I was there in Hawaii, when that the order to produce the children was served, and I was there when they served the search warrants, where the news showed up, which I was super annoyed by that. I never want it. It's just blows everything up, right? At that moment, when we saw them, because your sister can put on a brave face.
Oh, yeah.
We were like, oh, does this guy know what he's gotten into?
Mm-hmm.
And because she was just very, very stoic, very like, I'm not going to say a word. And he looked like he was about to pee his pants, because he's actually a wimpy person.
Yeah.
Is he wimpy?
Yeah.
He's great if he has someone else to do something for him, but he himself is a person.
Mm-hmm.
And at the time, they're like, this is all her. Like, how does she hoodwink this guy? But then once we like dug into, that was the beginning, as we're like starting to get facts. As we got more facts, like, oh, again, I'm not going to pull punches if I have to go to trial, but these ideas came from him.
Oh, yeah.
And she had some different views on theology than like standard LDS by that point, but he really knew how to manipulate that and turn it into something even more.
His influence was there before she met him.
Yes. Yeah, she was reading his books for.
It wasn't just his books. So it was like the Julie Rowe podcasts.
Oh, yes.
He gave Julie Rowe a lot of her ideas. And so when she would listen to Julie Rowe, she was getting Chad ideas too at the same time.
Yeah.
So.
Oh, yeah. Yeah, Julie Rowe. She's interesting.
Mm-hmm. I've heard some of her podcasts. When she started talking about herself in third person all the time, I'm like,
Yeah, I listen to her podcast as well, and interesting stuff. So.
Garrett doesn't like it when people talk about themselves in the third person.
Neither does Rob. Yeah. Well, hey, we'll let you get going and start on this.
I was going to see if you guys wanted some wristbands to take back with you. These are wristbands I had made up for Tylee and JJ.
Oh, I would.
And
That's all right.
Take them as you want.
Take them and give them to everybody. Or
I'll tell you what.
If you want them, we did a balloon release.
They've got a couple of wristbands for. Let's see. There's Ron, Ray.
You could just take the whole bag with you. It's fine. Just take
Oh, do you have more than this?
Oh, I have plenty.
Okay.
I had hundreds
You can't
of them.
order less than 100, so you know.
I made up hundreds for. I started off just doing them for Tylee and JJ's friends and teachers. We wear ours all the time, so just keep them close.
Thank you.
Yeah. Well, you guys.
Sorry.
That's all right. It's okay.
You've been in it.
It's an emotional thing.
It is.
It's interesting how you can, in Rexburg, those kids went very, very well. But there are kids.
Yeah.
Yeah.
And
Anytime there's kids involved,
Yeah.
it's not okay.
so, thank you.
There's
Yes.
not a one among us that doesn't want to protect the kids,
Right.
Yeah.
for
Yeah.
sure.
All right, I'll text Nathan. If you need, I don't know how long this, if we want to, we probably sit down and talk to you for days and days, and we obviously don't have that. But, any breaks you need anything?
Yeah, I'll run it, you bet, yeah. I told him she's got questions, needs to ask me or needs to use the bathroom, or we'll shut it down and
Thank you.
do all that, so.
Nice meeting you.
Oh, I'm on the wrong phone.
Good luck.
And Judge, I think that's the end of the tape.
Okay, thank you. And just so the record's clear, that was Exhibit 2 that was published. So, Mr. Pryor, you can proceed with your, or continue with your direct examination.
And Mr. Smith, are you still there?
Yes.
So, Mr. Smith, I've had an opportunity to listen to the tape several times and again listened to it today. Is it your position that Mr. Wood was trying to influence Ms. Shiflet to testify in a particular manner?
Well, I don't know what he was trying to do. I mean, I can't think of any other reason why he'd be doing that than for that purpose.
Well, that's what the question is can you come up with any conceivable idea as to why Mr. Wood would do that other than the fact that he was trying to coerce, intimidate, or manipulate a material witness in a criminal case?
Yeah, I other than for the purposes he stated, just to get to know them. But like I said, that was much, much more than that. It wasn't a simple meet and greet. That conversation had a lot more elements to it than that.
Well, and I want to go over a few of those elements, and I don't want to drag this on, but some of the elements that I want to go into is that Mr. Wood made reference to LDS speak and righteousness, invoking his religious beliefs to Ms. Shiflet. You would agree with me that knowing Ms. Shiflet, that would influence her in a certain way, right?
Yes.
And you would agree with me that Mr. Wood, being a former bishop of his church, invoking LDS speak and his religious beliefs, would have an impact on Ms. Shiflet. You'd agree with that then, correct?
Again, religion's very important to Summer, and her membership in the church is very significant to her. And that kind of a correlation was unnecessary in my mind to make that. Everybody knew that Rob was LDS and that he was Mormon, and I don't know if Summer knew that he was a bishop or not, and he didn't say that in this conversation. But again, that whole, hey, we're the same, we're on the same team here. We're, not only it just felt awkward and unprofessional to be talking that way.
Well, you're being kind in this case, because it was a little more than awkward. It was completely unprofessional. Wouldn't you agree with that?
Well, it was awkward for sure, and as I said, it was unprofessional.
All right, and the unprofessional nature is that he invoked his religious beliefs, right?
Well, you heard the tape. What he said is there's just that comment about righteousness, and I think when he was talking about the LDS speak, he wasn't necessarily trying to equate so much with Summer as he was with what Chad was doing, but just that whole notion and nature of that coming up was something I probably would have steered clear of.
Right. Well, you would agree with me that anyone on a supposed meet and greet wouldn't be invoking their religious beliefs in a casual conversation, right?
Yeah, it didn't have anything to do with the purpose for which that conversation was going on.
So we can assume then that the purpose of invoking the words LDS speak and then subsequent to that, a short time later, where he says, "Oh, I am LDS," the purpose of that was to gain favor with Summer Shiflet, right?
Yeah, it's the kind of thing that you're having a meet and greet and you're introducing yourself. You might want to tell them that you've got kids or something like that, which that's something that would be normal and even to everybody. But the religious side of it, again, you wouldn't do that in front of a jury, and doing it in front of a witness that hasn't yet testified, I found concerning.
Well, that's a good point that you bring up, and that's going to be addressed later on with some of the other witnesses. But if this sort of conduct, where you invoke your religious beliefs, and we're a prosecutor and you're a defense attorney, if you invoke your religious beliefs in front of a jury, that's an absolute mistrial and a disqualification of the prosecutor for prosecutorial misconduct, right?
Again, I would assume that it would cause problems. I gotta be honest, I've not looked at what consequences that would have, but I mean, it's absolutely taboo. I wouldn't do it, and I've not ever seen anybody do it that I've been involved with. It's just, it's more like vouching or saying, "Hey, I know this guy didn't do it." When you start talking about things like that or trying to equate with the jury every attorney that's in front of a jury is trying to build a relationship with them, but you have to be subtle about that. You can't just go, "Hey, any of you LDS? I'm LDS." It's just, it would be completely improper.
Well, not only improper, it's something that falls within the guides of professional conduct. That's a basis for opposing counsel to ask for a mistrial if anybody enters their religious beliefs in front of a jury, right?
Absolutely.
So my question is this, to kind of do a back way into this, Mr. Wood, on the supposed idea that he was going to do a meet and greet, proceeds to engage in Miss Shiflet. And by my recollection, he only asked a couple of questions, but there was a lot of discussion. And in that discussion, he invoked his religious views. So in other words, he's telling a witness who is going to be testifying in the trial, by the way, I'm LDS. By the way, I'm Mormon. Show me some favor. And that way, when you get in front of the jury and you offer that testimony, the intimidation and the influence has already occurred before you get in front of the jury. So in many ways, isn't that worse?
Your Honor, I'm going to object. Mr. Pryor's testifying. It's not a question. He's leading the witness to an answer.
I'll sustain the objection.
What's worse, doing this in front of a jury or coercing and intimidating a witness prior to the time they go in front of a jury?
Your Honor, I'm going to also object to the question. This doesn't have anything to do with the jury. It's just a witness in a case. So it's not relevant.
I'll sustain that objection based on relevance, and I think it did misstate the statements contained in the recording, which we just listened to. So that objection's also sustained.
All right, I'll move on, Judge. Thank you. What about calling a defendant in a case a wimpy person, Mr. Smith? Is that problematic?
You know, I know there's a lot of bluster that goes on in prosecuting people that do violent things. You know, I never prosecuted murder cases. I was involved with prosecuting child molesters. And there's a fair amount of banter that goes on amongst the professionals in there about these kinds of people. And so I've been to lunches where they referred to child molesters by lots of names that were demeaning and not nice and unprofessional. But it's in a professional setting. You know, I'm at lunch with other prosecutors or cops, and we're talking about, you know, what we think about child molesters. But in the context of talking to, you know, the sister-in-law of the individual that you're talking about, I didn't see a purpose for that, other than to, you know, kind of seed the ground for her testimony to be of a similar vein. And, you know, this is what we're looking for, kind of thing. And that was concerning to me.
And the concern is that Summer Shiflet is a witness potentially in this case, right?
Right. I mean, again, and I haven't been a prosecutor in a long time, but to talk to someone prior to them giving 6 hours of testimony and interview time on the facts of a case in this manner, I found it to be improper. I don't know what purpose it served, other than to you know, kind of muddy the water and make himself a witness. Well,
And make himself a witness because he then went on to discuss the fact that when he was in Hawaii, I don't know why he was in Hawaii other than apparently he was in Hawaii, but then he observes what he says is appears that the defendant, Mr. Daybell, appeared that he was about to pee his pants. What's the purpose of saying that to Summer Shiflet?
Your Honor, I'll object. That just calls for speculation.
I agree. It is speculative, but I don't know. That's my whole point. I don't know that. And Mr. Pryor, let me say this too, just in response to that last question.
Mr. Smith.
I'm sorry?
Mr. Smith, please.
Yes.
We're on a Zoom proceeding. We're making a record here. I have a court reporter.
Okay.
Wait until the questions are finished, and when there's an objection, please wait for the ruling on the objection before you continue with your response, please. Thank you.
Sorry, Judge, I'm not good at being in this seat. I apologize.
Understood.
Where are we at?
I heard an objection from somebody. I'm not sure who objected, but
Mr.
I'm waiting for the court's determination.
I sustain an objection by Mr.
All right, I'll continue on. Mr. Smith, you had some discussion about a prior question and that you had a comment, and if you want to relay that comment, by all means.
This conversation that I had with my client and Mr. Wood, you know, again, and just earlier I had testified that I didn't remember when I started the recording. From listening to the recording, I clearly started it after I got into the room. And to be completely candid with this court, my intent was to record the conversations of the interview. When I walked into the room with Mr. Wood, it had a less of an introductory feeling to it because he brought his deputy in with him. And again, part of the training that I received as a prosecutor and that I still employ as a defense attorney is that there needs to be somebody else in the conversation that can be a witness in case there's a dispute to that conversation. So if I'm interviewing a witness and I ask that witness about X, Y, and Z, and then they come into court and testify A, B, and C, I have to have some method of impeaching them, either through another witness or recording of the call or something like that. So a flag went off in my mind when he brought his deputy in to meet my client and myself, and to kind of do this introduction stuff. And that's when I got my recorder out and turned it on. That put a flag off in my mind that this wasn't going to be, hey, I'm John, or I'm Rob. This is my deputy, good luck today. Thanks for doing this. And we'll talk to you when it's all done. It was more than that. And that's when I turned it on. And I wanted to supplement my previous testimony. Like I said, I hadn't heard the tape recording in a while, and I didn't remember when I'd turned it on.
Okay. And when you make mention of the fact that a flag went off, you're referring to the fact that you felt that there may be some inappropriate discussion going to take place. Is that fair?
No, I didn't think it was going to be inappropriate. I thought it was going to be adversarial.
Okay.
And the fact that he was backing himself up with a witness told me, at least it made my, the flag, the spider senses, whatever you want to call it, the defense instinct, that I needed to be recording this conversation because he's got a witness in here. I need to have my recorder running. I had no idea that the conversation was going to go the direction that it went.
And having participated in the conversation, the 18-minute discussion, because this wasn't Mr. Wood questioning Summer Shiflet, was it?
No.
This discussion was Mr. Wood presenting his case to a witness. Would you agree with that?
Yes.
And Mr. Wood attempting to influence Summer Shiflet to testify a certain way. Would you agree with that?
Again, I don't know what his intents were, but I can't see any other reason to tell her the things that he did other than to steer her in that direction.
And when you say steer, you mean influence, do you not?
Correct. It's another word for that. Yes.
Okay. Judge, I think at this time, I'm done questioning with Mr. Smith. Thank you, Mr. Smith, and I'll defer to the court at this time.
All right, thank you. I'll allow cross-examination at this time. Mr. Evans.
Your Honor, thank you. Mr. Smith, thank you for being here today. Just a few questions. Where was the recorder at when this was being recorded?
It was my phone. It was this phone. And it was either in my hand or it was sitting on the table. I don't remember. I think we were standing for this conversation. I think we never sat down. We were standing in a small ante room off of the entry lobby of the Chandler Police Department. I think I'd set my stuff down on a table and my phone was on top of that.
And just so I understand this, Mr. Wood or the law enforcement, they contacted you and you contacted your client and you agreed to this conversation taking place, this meeting taking place?
Yes.
Mr. Smith, I mean, we're all lawyers. If something gets out of hand, and I know you've done this and we've all done this, but if I'm getting on your client's case, you can say, Evans, time out. Or I'm going to direct my client not to answer that question, or this interview is over, right?
Sure.
At no time during this meeting did you ever object to any question. Is that correct?
Yeah. I was doing what my client wanted to do, which was to participate in this interview. And you got to understand, I wasn't running it. She was running it. I was there as legal counsel and she wanted to do this interview. She wanted to give testimony. She'd been asked to give testimony in that sense. And so she was going to do that. I didn't want to shut this down, but that doesn't take away the concerns that I had at the time. There also wasn't a forum to go to. If I've got a problem with the question you're asking, I could object to it in a setting, not in this setting. It's not my position here, but there's a judge to go to, or hey, let's table this right now and straighten this out in a deposition or something like that. But it wasn't that type of setting. This was unique. Like I said, I've done this type of setting many, many times, but to have this kind of conversation was a little bit oh, we're doing this. Okay. And I didn't know where it was going to go. I knew I was recording it and I could deal with it later.
But you could have objected or told your client not to answer or ended the conversation, right?
Well, as was said, there wasn't a whole lot of questioning going on. In fact, I don't know there was any questioning other than, a couple of mild questions. It was mostly just conversation from Mr. Wood.
I want to talk about the tone. I mean, you hear you guys are joking a little bit throughout when it was discussed at the very beginning that murder charges might be coming on this. You said good, right? Do you remember that?
I don't remember that, but I don't dispute it.
Is your client a vulnerable adult by chance?
No.
Have any medical issues or anything that makes her incompetent to testify?
Not that I'm aware of.
And then finally, I want to talk about, you made an issue that Mr. Wood started talking about the death penalty or murder charges. I note from the audio, and I don't know, do you have the transcript in front of you, Mr. Smith?
No.
On page 11, starting in paragraph 5, it's pretty clear that your client was the one that initiated that conversation with Mr. Wood of talk to me about is death penalty on the table? What's going on?
I'm going to object at this
Yeah,
point.
you're not objectable. Go ahead, John.
Hold on. What's
Go
the,
ahead, I'll defer to Mr. Means, but I object from Mr. Evans questioning in this manner as suggesting that it's obvious that that's Ms. Shiflet that initiated it. I object to the form of the question.
Same, Your Honor.
the objection's overruled. You can continue. Were we referring to the transcript? I know that's been admitted.
I don't have it, but at least I don't think I have it.
Yeah. And let me just, so I actually misspoke. It's page 16, starting paragraph 2 through 9. But your client is the one that's asking Mr. Wood, what's the weight of the terms in jail? Is this a death penalty thing? Do you remember that, Mr. Smith?
I do. Yeah. She definitely initiated that conversation.
Okay.
Mr. Evans, if with the transcript being admitted, if you are going to refer to it, I think, and ask the witness to confirm that, it'd be appropriate if you can publish it based on, I don't know if you have, we should be able to enter it in. And so you can use your share screen to locate that part of it if it's on your computer, and then it comes up on the share screen on the Zoom if you want to do that. And if you're done with the question, that's fine. But for future reference, that's how we need to handle that.
Right. Thank you, Your Honor. And Your Honor, I'm done with that question. Mr. Smith, just a few others. I heard in the interview, Mr. Wood that told you and your client, hey, you don't have to talk to us, but you have agreed to that. Do you agree with that recollection?
Yes.
And it's important. My last question, you said that you didn't believe anything was inappropriate here, but you had a concern that it might turn adversarial. Can you tell us what you meant by being adversarial and not inappropriate?
Yeah, let me be really clear about that. When there was obviously conversation that had transpired prior to the beginning of the recording, we were several minutes into it by the time I turned it on, and the beginning of it did involve Mr. Wood introducing us to him and his deputy and thanking Summer for coming in, kind of like he ended the interview with, or the meeting with. And I went into it, to the day knowing that I was going to record the interview and was prepared to do that. I told my client I was going to do that, those kinds of things. But did not turn on the recording when I initially walked into this interview ante room with Mr. Wood and his deputy and my client. When I got in there and his deputy was in there, I thought, well, is he bring her in just to introduce, or was he bring her in to have a witness into there for the conversation? And initially the conversation was introductory, and this is a deputy, and we didn't know who she was. I'd never met her before. But then it went from that point to these other conversations, and that's when I reached down and turned on my recorder. Again, when I say adversarial, what made me think adversarial was the fact that he had a witness for the conversation. What made me turn on the recording was the topics and the the kind of the tone of the discussion at that point in time.
And Mr. Smith, last question. When you turned on the recording, you didn't say, hey, folks, just so you know, I just turned on the recording. I mean, we don't hear anything like that in any of the tape, right?
No, I did not, nor do I believe I need to.
No further questions, Your Honor.
All right, thank you. Mr. Pryor, do you have any redirect?
Judge, I think, do you want to give Mr. Means an opportunity to cross?
I will. Mr. Means, do you have any cross-examination?
Not cross, Your Honor, no.
Okay, and we'll get to your direct in a moment. Mr. Pryor, any redirect before we move on to Mr. Means?
Mr. Smith, the comment from the prosecutor about adversarial, that was initially what the concern was before you turned on the recording, correct?
That was my instinct, was that he's got a witness to the conversation. Is this going to turn adversarial?
Okay. And then after you returned on the recording, it was because you found the topics and the discussion to be highly inappropriate. Is that fair?
Yes, I wanted a record of it because we were discussing facts of the case, and it was, getting opinions from my client and sharing opinions from the state. It was that kind of conversation. They were discussing the death penalty. Where it turned on, it was already discussing that topic. That's when I turned it on.
Okay. And then it proceeded to go into disparaging remarks about the defense counsel for Lori Vallow, right?
Correct.
Disparaging remarks about Chad Daybell, correct?
Your Honor, I'll object to the disparaging remarks. There were remarks made that Mr. Pryor is testifying.
I'll sustain the objection in that the recording obviously speaks for itself. And the court can go through what was said on.
And what I'll ask Mr. Smith is, do you personally consider the remarks made about Mr. Means disparaging remarks?
I do.
Do you consider the remarks made about Chad Daybell disparaging remarks?
They are, absolutely.
Do you have any other explanation other than Mr. Wood trying to influence a material witness in a case for why he engaged in 18 minutes of discussion with Summer Shiflet?
Your Honor, I'll object speculation.
I'll overrule that. The witness can answer if you know.
As I said, I understood the purpose of the conversation to be introductory and kind of just a preamble to the interview. I see no purpose for the type of discussion that we had other than the reasons you suggested.
All right. Judge, I'll defer at this point on this witness. Judge, I would like to have this witness made available in the future in the event I need some rebuttal testimony. Thank you.
Okay, he won't be released yet. We're in the interest of efficiency. Then I talked about the procedure we'd use, but Mr. Means, we've got this witness here. Did you intend to call Mr. Smith as a witness in support of your motion as well?
I did, Your Honor. And just a few questions, not a lot.
Okay, then Mr. Means, if you'd like to commence with any direct examination, you can do so.
Thank you, Your Honor. Mr. Smith, I'll try to avoid repetitive questions here for efficiency of the court. You've listened to this recording. In this recording, Mr. Wood makes reference to speaking to, or sounds like speaking to, multiple people regarding this case. He uses terms of we, talks specifically about having a conversation with Colby. Are you aware if Mr. Wood has spoken with any other person directly in this case?
I'll tell you what I know, and that's just like I said earlier, that he had told me they were coming down here to interview witnesses. I don't remember that he gave me a list of who he was going to interview, but I mean, I could probably name half the list of the people that he spoke to. He did tell us in his conversations in the interviews, not him, the investigators told us some of the people that they had spoken with. But yeah, I understood he was down here talking to other witnesses about the case, and he may have been down to Arizona one other time. As I indicated earlier, this was, I think, the second setting that they tried to interview my clients in.
Okay. Did you have an opportunity to review a pleading filed in this case entitled "The Affidavit of Rob Wood in Support of Objection to Defendant's Motion to Disqualify Prosecuting Attorney and Motion to Extend Time on Motion to Dismiss"?
I did.
Okay, and this document, Your Honor, is obviously in the file. I'm going to read you paragraph 6 from this affidavit, and I'd like your thoughts on this. Says the meeting I attended with Mr. Smith, comma, Mrs. Shiflet and Ms. Pastenes came about as a result of Ms. Pastenes reaching out to my office and law enforcement through her attorney, Mr. Smith. Would you agree with that description?
Now, I don't know if Zulema ever reached out to his office prior to my representation, but I don't believe that I ever reached out on behalf of Zulema to initiate this. My recollection is that they contacted me and said, we'd like to talk to your witnesses or your clients as witnesses.
So would it be your opinion that that is not an accurate statement?
That's my recollection. And again, as I said, I don't know if Ms. Pastenes contacted them prior to my representation, but she never told me about that.
Okay. Well, it says in the paragraph 6, and I'm sorry, the last portion of the sentence, Ms. Pastenes reaching out to my office, in reference to Mr. Wood prosecutor's office, and law enforcement through her attorney, Mr. Smith.
Yeah.
So specifically stating it was you that reached out to arrange this meeting.
And here's the unique thing in answer to that question, Mr. Means, here's the unique thing about Ms. Pastenes. Her approach in my representation of her has been to keep her head down and stay out of the limelight and the attention. She's not done any interviews. She's not done any media appearances. She's not agreed to talk to anybody. And the only reason why she agreed to talk to the state is because they wanted to talk to her and they offered her use immunity. And so that's what got us to that point. It was not because she was anxious to talk to anybody, because she was not.
Okay. Okay. I think Mr. Pryor and Mr. Evans covered a lot of the questions I've covered, but I do have just a few more for you. In listening to this recording and the totality of the statement said, you've already testified that it appeared the motive to be influential of the witness. Would you agree it was attempt to coach as well?
The whole conversation, what the problem I have with the whole conversation is that, and I'm not saying that Mr. Wood was in there twisting arms or putting hard pressure on them. You know, I've been involved in situations like that where a prosecutor, threatens charges and things like that. That's the real weight of a prosecutor coming to bear on bringing influence on somebody. It wasn't that type of thing. It was the more subtle, I'm a nice guy, and I'm sure he is. You want to help me, help the state, help the case. It wasn't necessary. She was already there willing to participate. She didn't need any inducement or enticing in order to testify. I found it, and that's what my first concern about it was. I was like, why are we doing this? She's already come in, consented to all this. We didn't need to soften the beach with these kinds of comments. And so it clearly was to influence her. It clearly was to have her, kind of seated for this upcoming interview that she was going to have. And just, the next room we were going to go into was going to be this interview. And I saw no purpose for it. And I found it to be unprofessional and concerning.
Would you agree, especially taking in context the conversation regarding death penalty and the relationship in which you testified earlier between Mrs. Shiflet and Lori, that this conversation put Mrs. Shiflet in somewhat of a compromised position as a witness?
Look, as I said earlier, I've been doing this for 27, 28 years. I've been involved with legal practice for 30 years. I have never in my life heard a conversation like the phone call I heard between Lori and Summer. It was gut-wrenching. It is raw. It is horrible to listen to. And this is the emotional state of a witness, my client, who has lost one sister to death, another brother to death, and now another sister to jail and potentially death. And I found the whole conversation unnecessary and concerning. It was almost torturous to even be discussing about, well, we may take another member of your family. And I know Rob's not going to kill her. I mean, it's going to be a death penalty. It's going to be a process, and it's going to be, that whole thing. And but just the purpose of the conversation, I didn't see it. I don't know what it was going to do. And it was concerning to me because I know I've had conversations with Mr. Wood about that phone call between Lori and Summer, and he's aware of it. He's expressed to me in a very human way his concerns about how emotional that was and how hard that was for my client. So I found this conversation substantially concerning because of that history. This isn't a normal case. This is a weird case. And that history behind it, it bears explaining.
Would you agree that this conversation, again, looking at the totality of the situation and the relationship and the emotional connection in which you have described, would potentially impede a truthful, straightforward testimony from Mrs. Shiflet, given the context of this conversation?
Your Honor, I'll object for speculation.
Your Honor, I think we have if I may respond.
Go ahead.
Thank you. We have a witness here who has 27 years of legal experience and was involved in this recording and has obviously had multiple conversations with Mr. Wood and Mrs. Shiflet and has a better understanding than I think any of us regarding the totality of this situation, including the recording and what was before. His prior testimony discussing the emotional connection of Summer and Lori, and then having a conversation of death penalty and religious aspects and these type of things with the prosecutor, I think he's the person in the best position to offer us whether his opinion or not, or whether this might impede Summer's testimony. I think he should be allowed to answer the question, and then the court can weigh it for what it's worth.
All right. Well, the question really is whether or not this conversation would impede the witness potentially at some future hearing from offering truthful testimony. I think that does call for speculation, so I'll sustain that objection.
Thank you, Your Honor. Your Honor, I have no further questions for this witness at this time.
All right. Thank you, Mr. Means. Mr. Evans, cross-examination by the state in light of that direct examination.
None, Your Honor. Thank you.
All right. Mr. Pryor, do you have any cross-examination as it relates to
Mr. Smith, based on the discussion that took place between Mr. Wood, this wasn't an interview, was it?
No.
This was a narrative that Mr. Wood presented to your client, correct?
He did the majority of the talking, yes.
And the narrative that was presented was basically his ideas about how this case should proceed, right?
Your Honor, I'll just object. We've been down this road numerous times. We have the conversation, we've got the transcript. It just seems like we're hauling down old ground again.
I will sustain objection.
Do you believe the manner in which Mr. Wood discussed his theory and the facts of this case impacted Summer Shiflet?
Objection, again, speculation.
I'll overrule that objection if the witness has an answer.
Mr. Pryor, I'm sorry. You cut out partway through your question. I heard the objection and the judge overruling it, but I didn't hear the question. Could you repeat it?
The question is whether or not the discussion that Mr. Wood had with Summer Shiflet and presentation of his narrative impacted your client, Summer Shiflet.
I believe it did. Before I disclosed this, I had a discussion with her about why I was disclosing this, to get her authorization to disclose this conversation to another attorney. And she was in agreement with me doing that. Okay.
All right. No further questions, Judge. Thank you.
All right. Thank you. I think that concludes then the testimony of Mr. Smith. Mr. Means, you made some mention that, or Mr. Pryor, I don't recall, that you may want him still available for future testimony in this hearing. Is that correct?
It is, Judge. Thank you.
All right. Mr. Smith, I'm not sure what your day has in store, how long this hearing will be, but are you able to be available if we request to have you recalled in this matter?
Yeah, Judge, this is unique. Normally I would be in a courtroom and sitting out in the hall waiting to be recalled. Does that mean I'm going to go on mute, or I'm going to be unceremoniously kicked out of the room and admitted later? I don't know how, and I can do that, yes, or I could get a phone call or a text message saying, we need you again. I'm available, yes.
Judge, my preference would be that Mr. Smith, if needed, be contacted and asked to log back onto Zoom. I understand the constraints of an attorney and the time, so I think it's inappropriate to ask Mr. Smith to stay on, but if we need him, just see if we could get him back through a phone call or otherwise.
Okay. if you want to, we'll either put you back in the waiting room and you can just do other things, or if you'd like to just log off, Mr. Smith, then we will reach out to contact you at a future time if.
Great. You can go through. I'll log out. That's just fine.
All right, thank you.
All right, thank you.
All right, Mr. Pryor, who do you intend to call as your next witness?
Judge, I would call Dr. James Davidson.
All right, why don't we start then with your examination of Dr. Davidson, and then at some point we will take a mid-morning break, but we can do that here in a little bit unless, Madam Reporter, are you okay, or would you like a break at this time?
No, Judge, I'm fine. Thank you.
Thank you. All right, so Mr. Pryor, if you'd like to commence with your examination of your witness.
Do you want him sworn, Your Honor?
Mr. Davidson, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in the cause now pending will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Sir, would you state your name and spell your last name for the record for me, please?
Yes, it's James Davidson, Davidson.
Dr. Davidson, how are you employed?
I'm in a private practice of forensic psychology, doing civil, criminal, and family law in various states.
Okay, and can you tell me a little bit about your educational background, sir?
I have a Bachelor of Science in Psychology from Michigan State University. I have a Doctor of Philosophy from Kent State University in Psychology. I have advanced family law mediation training from Southern Methodist University. Hundreds and hundreds of hours of continuing education in forensic psychology matters, and have also done training for continuing legal education as well as of other psychologists.
Can you give me a little bit of information about your prior experience as an expert testifying in litigation?
I've testified in several states. I'm going to restrict this to criminal matters just for simplicity, but testified in various states on mitigation in Idaho, 1925-22 examinations, 18207 for mental status at time of offense, 18211 for competency, and then general forensic evaluations when there may not be in the criminal code a particular test or structure for a report for an issue. I've done hundreds and hundreds of these in various places, done insanity defenses in states that allow insanity defenses. In Idaho, of course, it's one of 4 that does not, and have done this for probably now 30 years.
Okay. And you mentioned forensic evaluations. Can you elaborate a little bit on what is a forensic evaluation?
Forensic evaluation is the intersection of a legal issue and a field of study, in my case, behavioral health. And so in every state, if we look at criminal issues, a forensic evaluation will deal with a particular issue. So if you have a mental state at time of offense, it is the culpability or the ability of the defendant to rationally be able to understand the consequences of their actions from a mental condition. If somebody has pled guilty to a charge, the court may require or want to have a mitigation report. What's their risk of future violence? What's their mental condition? And that would be used in consideration of sentencing. So a forensic evaluation is going to be an evaluation that will rely upon 5 principal areas. It's going to rely upon interview, testing, observation, record review, and collateral information as a structure, with the nature of the report varying depending on the issue presented to me by the court or by an attorney who's retained my services.
So in other words, asking or an attorney asking you to conduct a forensic evaluation, this is somewhat of a specialized field. Would you agree with me?
It's a highly specialized field, and I would agree with you.
Okay, and in this particular case, this conducting forensic evaluations, have you previously been identified and qualified as an expert witness in offering your testimony and opinion in regards to forensic evaluations?
I have in multiple states.
Okay, and how many times would you believe, you don't have to give me an exact number, have you been qualified as an expert witness to offer an opinion after conducting a forensic evaluation?
I'll tell you that most cases don't require testimony. They are reports used for settlement, or settlement occurs, a plea bargain. But in the last 5 years, looking at, pardon me, civil requirements that I have a 5-year history of testimony, I've testified in over 50 cases.
Okay, so a combination of your educational background and your knowledge in doing this, your skill and experience, you believe that you're qualified to offer an opinion based on what forensic analysis you've been asked to perform. Would that be fair?
Yes.
Okay. Judge, I'm going to move for this witness to be qualified as an expert witness for purposes of offering his opinion in this forensic analysis that he's been asked to perform in this case.
All right, there's a motion. Is there any objection to that, Mr. Evans?
None, Your Honor.
All right, Mr. Davidson will be considered an expert under the rules of evidence and under Idaho Criminal Rule 16 for purposes of this hearing. Based on that, so Mr. Pryor, you can continue with your examination.
Now, Mr. Davidson, I do want to relay that you and I have not spoken about this case prior to this, you being hired. Is that fair?
That's correct.
Mr. Means hired you as an expert to do a forensic analysis in this case. Is that correct?
Yes.
And as part of that forensic analysis, can you relay to the parties in the court what steps you took and what information you had to prepare your report?
Well, the steps that I first took would be to understand what's the nature of the assignment. And in doing an assignment of this nature, I'm always approaching it from a standpoint of I know nothing, I have no prior opinion, and that my task is to provide an unbiased report as if I was appointed by the court directly. So given that, I was informed that the task was to listen and review a recording and a transcript of that recording to determine my impressions based on my experience and training of the nature of that conversation, whether there were any issues or problems, if that conversation was put into context as being a conversation prior to an interview of a witness in a criminal matter. So I listened to the recording. I also went through the transcript and reviewed the transcript. And then based on the training and research that I did concerning interviews in a criminal matter of a witness, formulated my opinions and observations about the appropriateness, the inappropriateness of whatever occurred in that transcript and recording. And out of that generated a report called a forensic analysis of Summer Shiflet's interview by Prosecutor Robert Wood.
Okay. And that report was attached as part of a submission in this particular case. Is that correct? Or if you're aware of that, that's fine.
I didn't actually submit it. I turned that report into Attorney Means, and I'm sure he submitted it in whatever fashion he did.
Now, I would like to talk about the type of models that are used and how that affects your decision in this particular case. Can you discuss that with me a little bit?
Sure can. Interviewing any witness is an area of great concern because historically, going back decades, interview techniques have been highly prejudicial and biasing and have led to problems such as false testimony. It's led to omission of facts in testimony. And so over the years, internationally, there's been efforts to come up with various models of how to interview a witness to obtain as best as possible untainted, spontaneous information with a really fine grain of detail that would describe what that witness has to offer in testifying about a case. So I have listed in my report, and I'll just run through it very quickly, examples of very prominent models, both in this country and particularly in the United Kingdom and its those in its empire. There's the access model, which is an acronym that stands for assess, collect, collate, evaluate, survey, and summarize in interviewing a witness. There is the ABE model, which is in the United Kingdom for interviewing children, achieving best evidence. There's a conversation management model, which is based on the elements of reciprocity, response, and a managed sequence of greeting and orienting the interviewee. There's the peace model, which is used in the United Kingdom and Canada. And the peace model is one that's inquisitorial, but not confrontational or accusatory. And that came about because of issues that they'd had in prior criminal cases of prejudiced and tainted information in high-profile cases. There's the NICHD model. This is a model used particularly when there's allegations of abuse of a child or an adolescent. And it's a model that emphasizes elements that is common to the other models, such as open-ended questions. It emphasizes having a narrative to establish a robust level of testimony from an interviewee. It also establishes the fact that a person is going to offer to tell the truth. There's a Wicklander-Zulawski model, which is particularly used more in business, but it has the same kinds of elements to avoid civil litigation, where there's an emphasis on non-confrontational narrative rather than confrontational and a conversational approach to try to developing information from a witness. And then the granddaddy of everything that really spawned a lot of these models that attempt to get high quality, reliable information from the court is the Reed model, which goes back to the 40s and the 50s, which is used in criminal investigations where there is theoretically initially an interview of a potential suspect that turns into an interrogation. And the Reed model is one that has a lot of critics because it had and has become at times highly prejudicial in its techniques of refuting whatever a person would say in the interrogation if it doesn't line up with the theory of the investigators. So those are an example of various models that have been developed. And just parenthetically, those models were developed because there had been cases in various countries of people that were convicted only to find later that the evidence and how it was obtained and the way it was presented had prejudiced what people had to say, leading to convictions inappropriately of various people, going back to very, very publicly going back to the 70s.
Now, talk to me a little bit about the idea of best practices.
Well, best practices obviously is going to be in the eye of the beholder, but we know in the legal world that you have restrictions on how you can ask questions and the nature of the questions, and that you have to lay foundation to bring evidence into play into a court proceeding. We know in the behavioral health world that how questions are asked can lead to different answers. And so the effort in best practices is to codify as aspirational practices. What do you do to interview a person to get high quality information that avoids manipulation, that avoids suggestibility, and it avoids coercion? And in doing that, best practices, there's an effort to keep bias out of it, which is inherent in any interview. There's an effort to have it be fair. There's an effort to have the interview's information not be derived from closed-ended questions, leading questions, but open-ended to hear what do they have to say and develop that narrative robustly. There's an emphasis in best practices to have basic principles in play, that a person would act ethically. When I do forensic interviews, I'm doing it as a member of the American Psychological Association, also as a licensee in 7 different states. If I'm a lawyer, I'm doing under the American Bar Association and the Criminal Code of Conduct in a particular state. So ethics are important. Integrity is important because in a criminal case, we're trying to determine whether there's a level of guilt beyond a reasonable doubt. And that is based on testimony, where we're looking at people telling us the truth, acting honestly and with fairness, and in doing so, not manipulating information. So we have really an integrity issue that's important in best practices. We also have in best practices avoiding inappropriate interviewer behavior. Efforts to interview should not attempt to influence, exploit, shape, or misrepresent what a person has to say. And so, for example, you would not ask in the case of an abuse situation, tell me where they touched you. You would start off with asking, tell me what happened, and maybe nothing happened. So you can see very easily how a question could influence the response of a person. In best practices, we're looking at being sensitive to vulnerable witnesses so that there's not any sense of undue influence. Vulnerable witnesses can be people with cognitive difficulties, emotional difficulties, people that are emotionally highly engaged or tied into a matter, people that have age issues, that have issues of fatigue. Sometimes there's cultural issues. And so with a vulnerable witness, it's very, very important that the level and the professionalism in the interviewing be at its very, very best to avoid misunderstanding and avoid having a person be misled and guided in their testimony rather than offering unfettered, free, and accurate testimony. And best practices, just to wrap it up, typically there's an opening procedure that goes by the mnemonic of GMAC, where we have a greeting, we have an explanation, we have a definition of the mutual activity. We're going to do an interview on such and such. This is how we're going to do it. And then a closing, thanking somebody for appearing. So best practices are anticipated and expected. And certainly in a case where there would be, from a forensic psychology standpoint, a forensic interview, if I did not conduct that interview, for example, in an allegation of abuse by NICHD standards, which are similar and identical to what's used in a child advocacy center, my testimony should rightfully be challenged. If I interviewed an adult and I'm doing a mental state at time of offense or an insanity plea, my interview needs to be done as neutrally as possible, because I'm retrospectively trying to determine what that person's mindset was 6 months, a year, 2 years in the past. So the best practices is pivotal in any of the activities that involve interviewing of people in a forensic setting.
And to follow up on your response, best practices also involves not invoking any bias or feelings or prejudice to someone that you're talking to about a particular case. Is that fair?
I don't think, yes, it is fair. I don't qualify it in saying that in any situation, there's always some amount of bias, and it's difficult because if you're the person doing the interviewing, it's hard to see the trees for the forest. But yes, to minimize bias is critical.
Now, you had an occasion in this case to review the tape recording that Mr. Means provided to you. Is that correct?
I did.
And you had an opportunity to review the transcript that's been admitted as, I believe, exhibit number 1 in this particular case. Is that correct?
Yes.
And as part of that process, you prepared a report, approximately 24 pages, detailing your findings in regards to that review. Is that correct?
I did.
And based on your experience and knowledge in this case, and having testified numerous times, you came up with some conclusions regarding and findings regarding this tape recording. Is that fair?
Regarding the narrative on the recording, I did.
And before I start, I guess I want to clarify something. You're aware that this recording took place. Would you describe the interaction between Mr. Wood and Ms. Shiflet in the first 18 minutes as an interview?
No, not at all.
What would you describe it as?
I would describe it as a session or a meeting where the witness was obviously being greeted for the first time, to educate and inform the witness of the prosecutor's perspective, theory on the case, and to elicit the participation of the witness in that theory of the case.
Okay. And Judge, I have a lengthy discussion that's going to take place with Dr. Davidson. I would ask if the court wants to take a break at this time before I engage in this lengthy discussion regarding his findings, or would the court like me to proceed? And I will defer to the court's wisdom.
I think this would be a good time to take a mid-morning break, so we'll do that. Before we move on, there was one concern I wanted to address there with Mr. Davidson. Mr. Davidson, in offering your testimony here, are you have you been reading from or referring to anything outside of just your own memory here? I had a concern.
I have reviewed carefully my report, Your Honor, but I'm operating on my memory in preparation for this hearing.
Okay, understood. I just want to be, it's a little concerning when we do these Zoom hearings that everybody's on a computer, but we don't always know what's there. So I just want to make sure you do testify. If you are referring to something, we need to put that on the record and know what you're referring to and give an opportunity for a possible objection. So keep that in mind as we move forward with your testimony. With that said, why don't we take a break for about 20 minutes? So let's plan on starting up again at about 10 after. Is that okay with everyone?
Yes, Your Honor.
Yes, Your Honor.
All right, thanks, counsel. We'll come back on and continue this hearing at 10 after.